Hello, my name is Tanner Hugazeli, and I'm a registered Canadian patent agent at the patent and trademark agent firm Craig Wilson & Company in Mississauga, Ontario, Canada. In this video, I'll be discussing the process for searching, applying for, and acquiring patent protection in Canada for your invention. It's not an entirely straightforward process, but I do look forward to describing it to you in more detail. Let's get started. A recommended first step in the patent process is to have a patent search made. The idea behind a patent search is to locate patents and published patent applications which are in the field of technology to which your invention relates. I say that a search is recommended because it is not a mandatory part of the process. However, it is strongly recommended that you have a search made before proceeding with filing a patent application. Drafting a patent application and filing patent applications, especially in more than one country, is a substantial monetary investment. A patent search provides you with an assessment of the patent activity in your technology area. It will also provide you with a likelihood of success in obtaining patent protection for your invention and an estimate on what the scope of protection will look like once that patent protection is obtained. This can be helpful information to know before you decide to invest in having a patent application drafted and filing in one or more countries around the world. If the search fails to locate a reference which covers one or more features of your invention, then you may have an invention which is clear of the prior art and for which you may be able to obtain patent protection should you decide to file a patent application. I strongly recommend you reach out to a registered Canadian patent agent, such as myself, to have your search made. A patent agent is in the best position to provide you with an assessment of the prior art, what it means, and how it will impact your patent application going forward. Assuming the search comes back favorably and your invention has at least one feature which is clear of the prior art, then the next step is to have a patent application drafted. Drafting a patent application is a complicated process with many do's and don'ts, so we recommend that you reach out to us to assist you with this important step. A patent application includes a description of your invention and how you've put it into practice, drawings if your invention or parts of it can be illustrated, and a section at the end called the claims which outline the invention which you believe to be your exclusive property. Drafting a patent application is a very involved process, and you can expect to be speaking with your patent agent at numerous times throughout the drafting process. Once you're in agreement with the patent application and there are no further changes to make, then we can proceed to the step of filing your patent application in a first jurisdiction. The first jurisdiction might be filing directly into a country such as Canada or the United States, or it may involve the filing of an international application. The optimal filing strategy for your invention should be the subject of a discussion that you have with your patent agent before you choose which jurisdiction to file in first. Once your patent application has been filed, it will remain confidential for a period of 18 months and will then be published. This time frame is the same in most jurisdictions, so for now, let's assume the application that we're talking about has been filed in Canada. Sometime after publication, your patent application will be examined by a Canadian patent examiner. The examiner will review your application for compliance with the Canadian Patent Act and the Canadian patent rules. They will also do their own patent search to locate their own prior art references. If the examiner has any objections on the basis of formalities or in view of a prior art reference, then the examiner will issue an examiner's report, also known as an office action. During the examination process, you should expect one or more office actions to be issued. Each time an office action is issued, you will be offered the chance to provide arguments or remarks as to why the examiner should withdraw the objection, or you may also enter amendments to your application in order to overcome the objections raised by the examiner. If your patent search was thorough, then any references raised by the examiner should not pose a major issue. Once the examiner has no further objections to raise, then the examiner will issue a notice of allowance. Notice of allowance provides you with a deadline within which you may pay the final fee or the issue fee for your patent application. Once the issue fee is paid, some weeks later, your patent application will proceed to grant. Once your patent application is granted, you will then have the right to exclude others from making, using, or selling your invention in Canada. On average, you should expect the process from filing your application through to grant of your patent to take anywhere from 3 to 4 years in Canada. It's best to partner with a Canadian patent agent to assist you with this relatively lengthy and certainly not entirely straightforward process. It's been my great pleasure to speak with you today about the process for acquiring patent protection in Canada for your invention. Thank you very much for joining me, and I look forward to seeing you next time.